My name is Tariq Ahmed, and I'm a foreign law specialist here at the Law Library of Congress, where I cover South Asia. I would like to warmly welcome Dr. Waris Hussain as a guest co-presenter of today's webinar. Dr. Hussain is an adjunct professor of international law at the Howard University School of Law. He holds a SJD degree from American University, Washington College of Law, specializing in constitutional and comparative law. His dissertation focused on the development of judicial review in the Supreme Courts of Pakistan, India, and the United States, which was published in 2017. He received his LLM in International Human Rights Law from the Washington College of Law at American University and his JD from Howard University School of Law. We would like to greatly thank him in advance for providing us with his insights and expertise on this subject. This webinar will focus on providing an overview of the recent judicial reforms made pursuant to the 26th Constitutional Amendment and its significant impact on Pakistan's political and judicial landscape. Dr. Hussain will begin the discussion by providing a brief overview of Pakistan's political system and judiciary. Then he'll provide the historical context and recent background leading up to the reforms, touching on Pakistan's judiciary's evolving role in the country's legal and political system. Then we'll delve into the passage of the bill, its process, while highlighting some of the political dynamics, negotiations that facilitated its enactment. Next, we'll outline the main features of the bill, focus on key areas such as the composition of the Judicial Commission of Pakistan, the appointment process of the Chief Justice of Pakistan, the formation of constitutional benches, the restriction on suo motu powers, among other critical changes. From there, we'll consider implication of these judicial reforms for the judiciary's independence and separation of powers. Lastly, we'll discuss the legal court challenges that the amendment faces and where they might lead. Dr. Hussain, if you can start us off with the broader context and historical setting and some of the recent background leading up to these reforms.
Yeah, thanks, Tariq, for that introduction as well as for hosting this very important discussion. As we'll probably get into throughout this discussion today in this hour, the 26th Amendment has been a transformative sort of moment in Pakistan's judicial and political history, and it has really had a large impact already. And it's caused a lot of conflicts that we'll talk through and discuss today. But before we do that, I thought it would be important that we give a little bit of a background before we delve into the specifics of the Constitution and of the amendment that's been passed as it relates to the Supreme Court and the High Court's powers in Pakistan. As you see here, we wanted to kind of show you at least the structure of the government in Pakistan. It's a three-branch sort of system. You have the executive through the Prime Minister's office, you have the parliament, which is the sort of like the akin to a congressional body, and then you have the judiciary, which is the third sort of branch. Within the judiciary, you have the Supreme Court, which sits at the top of the judiciary. There's also the Sharia court, which sits in some ways is parallel to the Supreme Court, but really the apex court of the land under the Constitution is known as the Supreme Court. Then you have underneath that you have federal Sharia courts. You have high courts and provincial courts, and then you have city courts and sessions courts on the lowest level. So that's essentially what the framework of the judicial system looks like. The Supreme Court is on top, then really you have the high courts underneath that, and then you have courts underneath in each one of the provinces or states in Pakistan. As you see in the parliament, you have the president's office, you have the Senate, and you have the National Assembly. Then you also have provincial assemblies for each one of the four major provinces in Pakistan. And in the executive, you have the prime minister, you have the federal cabinet, which has advisors and ministers in it. All of these, bubbles that you see here or squares that you see here have had a part to play in the amendment, the 26th Amendment, as we'll discuss today. So I wanted to kind of lay out for you what the overlay or what the general sort of shape of government looks like according to the Constitution in Pakistan before we go into that. Could we go to the next slide, please, Tariq? Now, I think it's really important now that we have the structure in mind to also think about the historical setting of judicial power in Pakistan and of the background to the 26th Amendment, which tries to, in some ways, curtail that expanding power that we've seen in the judiciary for quite a bit of time. Now, the previous slide showed you all of the ways the Constitution designates power through the different branches, but then you also have in Pakistan military takeovers and rule by military leader or ruler. So in 2007, there was an attempt by then I guess, president, I guess he called himself at that point, Pervez Musharraf, who was a military ruler, a military dictator, part of the military apparatus in Pakistan that had taken over power for quite a bit of time. And around 2006 and 2007, the Musharraf regime was trying to limit some of the powers and some of the seniority that's allowed to judges and interfering essentially with the independence of the judiciary. There was a deposition of the Supreme Court Chief Justice at one point, threats against a lot of the justices' lives, because the military was trying to hold back any kind of semblance of checks on their power, which the judiciary was trying to, at least in some ways, enact. This led in 2007 to the lawyers' movement. And the lawyers' movement, or it's called the Black Coat Revolution, because all lawyers in Pakistan have a court attire, which is, a white shirt and a black blazer. The Black Coat Revolution essentially was a democracy movement that was pushed forward by lawyers, by judges, led by, members of the judiciary and led by members of bar councils and practitioners of law around the country who came out in support of democracy, who came out in order to essentially depose the military dictatorship that was existing at that time. And through collaboration with political parties and other sort of, vested interests in Pakistan, they were able to bring about a democratic sort of revolution, as we would call it in Pakistan. And the lawyers were very essential in bringing that forward in 2007. Subsequent to that, if we fast forward a couple of years, the Supreme Court begins to exercise powers that it had previously, throughout its history, since Pakistan's independence in 1947, had never sort of enacted or taken the lead on certain issues. And in many ways, this manifested in sui moto decisions, and we'll talk about sui moto in a little bit. But practically, what sui moto means is that by the court's own cognizance, they can take up an issue, or by hearing petitions or pleadings that brought the court into an unprecedented area of power. One of those examples was the deposition of the removal of the then Prime Minister Yusuf Raza Gilani in 2012. That happened through a Supreme Court order, essentially, and through many different ways. Every democratically elected Prime Minister since Gilani, whether it was the Nawaz Sharif government or whether it was the Imran Khan government, has been brought down in some way, shape, or form through the Supreme Court's sort of actions, or taking up petitions that challenge the power of the prime minister. So this becomes a key central sort of moment in 2012, where the Supreme Court has removed a democratically elected prime minister because of allegations that he was being untruthful and other allegations against him. But then they have subsequently continuously exercised that power, that as an unelected branch, the judges are now removing the elected sort of politicians in the other branches of government. And that's a very important and I think landmark moment in the Supreme Court's exercise of its powers, but also has led to this very distinct, I think, conflict that exists between the political arms of the government, whether it's the Prime Minister's office or Parliament, and the judiciary, as we're seeing it manifested today. Could we go to the next slide? I also wanted to give a few examples of where there was even members of the judiciary, were wondering, has the judiciary or the Supreme Court gone too far in its exercise of power? One of those examples was the Chief Justice's sort of partnership with the Prime Minister's office to solicit private donations from citizens to build a dam, a dam to hold back water, essentially a major project that would otherwise have been consistently and comprehensively been an action of either Parliament or the Prime Minister to build these kinds of mega projects, maybe in collaboration with some international financial institutions, whatever it may be. But in the past, we would see sort of political actors taking action on whether a dam should be built or should not be built. But here, the Supreme Court, through its own volition, through its own actions, created a private fund for people to submit money to, and called it the PMCJ fund for the dam. This was, I think, highlighted by a lot of political actors as well as by members of the judiciary who were wondering, is this an overextension of power by the Supreme Court? In the same year that the fund was created in 2018, Justice Saqib Nisar, who was, known as a very activist judge in Pakistan Supreme Court history, was visiting various hospitals, psychiatric wards, in front of cameras as the Chief Justice of Pakistan, evaluating the administration of these government-run facilities, criticizing the staff for not providing good enough services for individuals who were there, patients in those facilities. And again, I think as a general point, perhaps a citizen walking into one of these places and saying, "Oh, this isn't very well kept. We should provide better services to people," is one thing. But when the Chief Justice of the Supreme Court leaves the Supreme Court building and goes, as the Supreme Court Chief Justice into these areas and has a very public sort of like, with media present and everyone else there criticizing the government and criticizing the people who are running these facilities, it was questioned whether the Supreme Court's power has gone too far. Now it's not even in the courtroom anymore. It's extended to these kind of on-site surprise visits by the Supreme Court Chief Justice. This was part and parcel of the sui motu power of the court. And the sui motu power of the court, will I think, talk a little bit about later. Tariq will especially mention it as it relates to the 26th Amendment. But the sui motu power of the court essentially means that without any petition, or without any formal appeal being sent from lower courts, the high courts, the additional or sessions courts in Pakistan, the Supreme Court Chief Justice can literally pick up a newspaper one day, see a story that's been reported on, and say, "This is an injustice that I don't want to happen," and then can call parties before the Supreme Court to adjudicate the matter. The idea here behind it is that because justice delayed can be justice denied in Pakistan, and there is a large backlog of cases, the sui motu power is an ability for the Supreme Court to, directly impact justice in a specific instance. Critics have said that this really creates a very dangerous sort of precedent of power for the judiciary, where they can enact any kind of orders or jump into any situation or scenario without satisfying, the issues of standing or the issues of exhaustion of remedies at the lower courts, considering it is the apex and highest court. Supreme Court sui motu powers have been both criticized by some, but also held up by some as a means to ensure that people who are not generally getting justice in Pakistan can get justice at the apex court. So there's both of those countervailing perspectives, but the usage of that power has been completely unregulated, and in the past was really under the discretion of the Chief Justice alone. So the Chief Justice could decide to take as many or as few sui motu cases without providing any justification for the ones that they took. And then to the next slide, Tarek, could we go there? Then there's also questions about when they don't take sui motu action, right? So if they're taking sui motu action in some instances, when they don't take sui motu actions or take petitions from people who are asking the court to enact its sui motu powers, there are also questions raised by people, petitioners or public at large, who might say, well, what is the rule? What is the actual sort of law that's controlling the ability of the Supreme Court Chief Justice to be able to actually use this very wide-ranging power? And one of those examples happened during the PTI protest. PTI is the Pakistani Tehreek-e-Insaf, led by Imran Khan, a former cricketer who then became the leader of a large opposition party and then became prime minister himself, and now is currently facing dozens of criminal charges. And his party has faced a lot of, very significant pushback from various different political, military, and judicial actors in Pakistan. In any case, the party was organizing street protests. During these street protests, both police and protesters were killed, and so there was petitions sent for the Supreme Court to use its sui motu power to provide justice to the people in those instances, the families of the lost ones, to be able to get some kind of remedy. And the Supreme Court denied taking up the sui motu action, which then brought up criticism from the political actors, from the PTI in particular, as a party, who said, why is the Supreme Court using its sui motu in some instances, but not in instances that impact us? Next slide, please, Sadi. And so that brings us to the recent background of what the 26th Amendment was attempting to do, or what was the sort of environment in which it fell in. There was a deteriorating relationship between the executive and the judiciary, both since 2024 in the national elections that were held in February, but also earlier, as I mentioned, going back to 2012, when the Prime Minister, Yusuf Raza Gilani, was removed. That's a long-running conflict between the executive and the judiciary, and definitely manifested itself in 2024 during the nation's elections. Certain Supreme Court rulings were perceived as in favor of the former Prime Minister Imran Khan and his political party. At the same time, some were seen as very aggressively anti-Imran Khan and anti-PTI, and we'll get into both. But one of the examples we can give here is that the Supreme Court held in favor of the Imran Khan government, or not the Imran Khan government, but the the Pakistani Tehreek-e-Insaf, as it related to the reserved seats case. Reserved seats are essentially affirmative action type of seats that are held in parliament so that people who are underrepresented, whether they're from, are women or from non-Muslim sort of, religious groups, various different individuals are granted reserved seats in Pakistan's parliament. Each party has a certain amount of reserved seats that they can sort of appoint individuals to. The PTI was denied by the Election Commission in Pakistan their ability to get their portion of these reserve seats filled by PTI members. And subsequently, the Supreme Court actually overruled the Election Commission, saying, in fact, the PTI should have been able to get some reserve seats and to be able to appoint individuals to those reserve seats. So there was an instance where the Supreme Court was holding in favor of the PTI and Imran Khan's party. And there are other examples that we'll probably get to later in the question and answer session, where the PTI had alleged that perhaps they were not being treated as fairly by the Supreme Court as other political parties were. Then we had the initial proposition or the initial sort of introduction of the constitutional package, which then became the 26th Amendment, which had more than 50 proposals. There was an idea floated for a while to create a separate federal constitutional court that was separate from the Supreme Court, although that sort of distinctive court and the breakup of the apex judiciary, which was attempted or at least brought up by certain political parties, was eventually abandoned, and then they allowed the Supreme Court to remain the apex court, but then create a constitutional bench, which we'll talk a little bit about in the specifics of the 26th Amendment. But essentially, one of the proposals was, in fact, let's create two apex courts, or let's separate the Supreme Court from a federal constitutional court and create a whole new constitutional court that was separate and distinct from the Supreme Court. Of course, that didn't go through, and they changed that to a bench, but that was one of the proposals put forward. There were also other sort of rumors that were floated that talked about the tenure of the Chief Justice of Pakistan being extended. The tenure as it exists previously under the rules was that every judge on the Supreme Court has to retire at 65. So however much time you have between being appointed as the Chief Justice of the Supreme Court and the time that you're 65 is the period that you have to be Chief Justice. You're automatically terminated from that post at 65. There was a question that was raised that would try and extend the tenure of the CJP or the Chief Justice of Pakistan beyond that 65-year requirement, or to increase the number of judges on the Supreme Court bench from I believe it was 17 to, I think one of the numbers that was floated was 35 judges, almost doubling the number of judges on the Supreme Court. The government, in its proposals for the 26th Amendment in this constitutional package, was essentially saying we need to improve judicial efficiency. We need to give power back to Parliament. We need to retain parliamentary sovereignty because they felt as if the Supreme Court and the judiciary had usurped some of the powers that should be with Parliament and the political arms of the government. There were reports that indicated that there was a very rushed and hurried process to pass the amendments before the retirement of the then current Justice, Chief Justice Issa, because Chief Justice Issa was seen as a sort of part of the judiciary that would allow for the 26th Amendment to actually happen and to facilitate the implementation of the 26th Amendment. Several other judges on the Supreme Court, as we'll discuss later, were not okay with the 26th Amendment and are still in a place where they're questioning the validity and constitutionality of the 26th Amendment because they think that it confronts or affronts or rather violates the independence of the judiciary. But Chief Justice Issa was seen as a friendly towards the 26th Amendment sort of movement. And so there was an idea to try and rush through the amendment while Chief Justice Issa was in power so that they could allow it to be upheld and remain as part of the Constitution. There was a lot of accusations made by the PTI, which is the party that I mentioned before, accusing the government of passing the amendment in order to target the former Prime Minister Imran Khan, to target any political opposition that might exist, which is really led by the PTI at this point in Pakistan as the largest opposition party. And so many saw that this sort of politicization of the judiciary, as we'll see through the elements that Tariq will describe from the 26th Amendment, was actually a means to shut down certain political parties like the PTI. Tariq, over to you.
Now, I want to discuss briefly, give an overview of how the constitutional amendment was actually passed. Now, in Pakistan, an amendment to the constitution can be made through an act of parliament. Constitutional amendment bills can originate in either house, and each house must pass the bill with a two-thirds supermajority of the total membership of that particular house. If the second house passes the bill with amendments, it is referred back to the original house in which the bill was originated. If that house agrees to the amendments with a two-thirds supermajority, the bill is sent to the president for assent. Now, the initial push for judicial reforms began in September 2024 and was expected to be tabled, the initial package, as Waris had mentioned, was expected to be tabled on the 16th of that same month. However, the Nawaz Sharif government deferred the tabling of the constitutional package, which, as Waris had mentioned, had include proposals regarding the establishment of a federal constitutional court, increase the retirement age of superior judges, and change the appointment process of the Chief Justice, essentially because they lacked the necessary two-thirds majority vote needed to pass the bill. The initial reform package was rejected by key opposition parties, and bar associations and lawyers fiercely opposed it. And I think that one of the main sticking points that Waris has mentioned was the proposal of the Federal Constitutional Court being a key sticking point. Now, on October 18th, a breakthrough was achieved through a political agreement facilitated by a special parliamentary committee comprising government and opposition parties. This approval had preceded by an agreement between the center-left dynastic party, the Pakistan People's Party, and the Islamic party known as Jamaat-e-Ulama Islam, under the leadership of Fazlur Rahman. Fazlur Rahman had initially rejected the government's proposal because of the Federal Constitutional Court, but once that proposal was dropped in favor of establishing constitutional benches, political consensus was more easily reached. Now, on October 20th, the federal cabinet reviewed and approved the amendment bill. That same evening, the Senate, Parliament's upper house, passed the bill within hours of its introduction, reflecting the government's sense of urgency. The following day, on October 21st, the National Assembly voted in favor of the bill, with the government securing 211 votes, supported by the PPP, the GOIF, and other small political parties and independent candidates. They were also able to get some other PTI-backed candidates who switched to the government side. Now, by the end of October 21st, President Asif Ali Zardari granted his assent to the bill, and it was officially published in the official gazette, marking its passage into law. Now, the rushed process has drawn some criticism. Some PTI lawmakers who are, as Waris has mentioned, are supporters of the former Prime Minister Imran Khan, alleged coercion. There were claims that bribes were made and political concessions had been made. Dawn reported that several PTI members and their families felt that they were intimidated and that the cases were being brought against them to secure their support for the bill. Now, the International Commission of Jurists have also criticized the lack of transparency, stating that the draft amendments were kept secret with no public consultations. Now, despite these concerns, the government maintained that these judicial reforms were necessary to improve judicial efficiency, tackle judicial overreach, and reinforce parliamentary sovereignty. Now we're going to cover some main features of the bill related to judicial reforms. Note that the bill covers a lot of other matters that are not tied directly to judicial reforms, like the addition of a new fundamental right to clean and sustainable environment. So the focus of our presentation will be related to judicial reforms rather than every aspect of the bill. The amendment bill introduced significant changes to the composition of the Judicial Commission of Pakistan under Article 175A. Now, the commission was initially introduced by the 18th Amendment to oversee the appointment of judges to the superior judiciary, including the Supreme Court, High Courts, and the Federal Shariat Court. Now, before the amendment, the commission primarily consisted of a judicial majority led by the Chief Justice of Pakistan as a chairman, along with 4 senior-most judges of the Supreme Court, a former Chief Justice or judge of the Supreme Court, the Federal Minister for Law and Justice, the Attorney General of Pakistan, and a senior advocate nominated by the Pakistan Bar Council. Dr. Hassan, you wanted to chime in here about the 18th Amendment and how it itself was under judicial contestation. Why was this important as a part of this discussion?
Yeah, I think in particular, it's important to remember that under Pakistan's sort of judicial history, there's a salient features or basic structure doctrine concept that's been floated and teased with in various benches by the Supreme Court, which means that even if Parliament passes a constitutional amendment, and remember, the Supreme Court is supposed to interpret the Constitution, right? Even when Parliament duly does amend the Constitution in some way, i.e., through the creation of the JC, which happened under the 18th Amendment, the Supreme Court can look at the salient features of the Constitution, and if that amendment violates the salient features or the fundamental sort of parts of the Constitution, they can overrule or they can send back to Parliament that amendment and tell Parliament change this amendment or alter it in some way. And so the question about the appointment process that was put forward in the 18th Amendment did sort of initiate a lot of hearings and a lot of cases before the Supreme Court challenging the validity of the 18th Amendment, especially as it relates to the appointment of judges. And its interpretation was very narrowly applied through the Supreme Court. And so parts of it were definitely upheld in the 18th Amendment and the Supreme Court. Parts of it were definitely pushed back for at least a second review by parliamentary council and commission. So that's something I just wanted to mention because at the end of this presentation, we'll talk a little bit about the current challenges to the amendment, to the 26th Amendment. And many of you may be wondering, why would there be challenges to a constitutional amendment? It's a constitutional amendment. But in fact, through the salient features and basic structure doctrine concepts, the Supreme Court has exercised the ability to review the constitutionality of constitutional amendments. I know that sentence is very confusing, but that is what the powers of the Supreme Court can be in many instances.
So now let's look at some of the changes made by the amendment. So it basically alters this balance by adding parliamentary non-judicial members. It introduces 2 members from the National Assembly and 2 members from the Senate. Of these, 2 are from the Treasury benches, which are basically the government members of Parliament, 1 from each house. 2 are from the opposition benches, 1 from each house as well. The Treasury bench members are nominated by the leader of the House, while the opposition members are nominated by the leader of the opposition. Additionally, 1 member must be a woman or non-Muslim who is not a member of Parliament, basically a technocrat, and they're nominated by the Speaker of the National Assembly for a 2-year term. The amendment also introduces a presiding judge, reduces the number of senior judges from 4 to 3, and removes the former Chief Justice or former judge of the Supreme Court from the commission itself. Now, this reduces overall the judicial representation and effectively grants a more significant role to the executive and Parliament in the judicial appointment process. Additionally, the experience requirement for the lawyer who representative lawyer has been specified to a minimum of 15 years practice in the Supreme Court. Now, the commission has previously faced criticism for a lack of representativeness, diversity, and transparency in its appointment process. The government has justified these changes by citing the need for greater transparency and advocating for a meaningful role for Parliament in the appointment process. Critics, on the other hand, to these changes point to the shift in balance of power towards the government and Parliament, raising concerns about increased political influence in judicial appointments. The appointment process of the Chief Justice of Pakistan has also undergone significant changes with the 26th Amendment. Before I get into details of this reform, I wanted to give Dr. Hassan a brief chance to discuss why the appointment process of the Chief Justice, in terms of the scope of his powers, is such a fraught and contested area of reform in Pakistan.
Yeah, I think there's a few, AKAs perhaps for the Chief Justice that we can kind of remember and may help us understand why this is such a hot button issue, the appointment and the promotion of a justice to Chief Justice. One of them is that, this is very gendered, but this is what it's called. It's that the Chief Justice of the Supreme Court is known as the pater familias of all of the judiciaries in Pakistan, meaning that the Chief Justice of the Supreme Court is the father or the mother, as we could call it, of the all of the judiciary. So they're known as being the leader of all the judiciary. So that includes the high courts, that includes the session courts, essentially the apex court, and the apex person on that court is the Chief Justice. The second AKA that I'll mention is that the in the past, comparative constitutional sort of scholars like myself have called the Supreme Court of Pakistan the Chief Justice's court because the Chief Justice exercises so much authority and power, i.e., through the use of sui motu powers that were, really in the sole hands and control and discretion of the Chief Justice before all the changes that we'll talk about today took place, as well as the composition of benches, which was one of the roles that Tariq will talk about in a little bit, is also the master of the roster. Essentially, that because Pakistan's Supreme Court is so busy, it has so many different benches operating at one time, it's very important who is appointed to which bench, right, for certain decisions to be made. And through the past powers of the Supreme Court Chief Justice, the Chief Justice and their office alone had the ability to determine which judges sit on which cases, which is a very, very important sort of role. So, as the Pater Familias, as the Supreme Court is known as the Chief Justice's Court, and as the master of the roster, I think the powers of the Chief Justice are very, very large in the Supreme Court, and therefore the appointment process is very fraught with a lot of very distinct opinions because so much power is vested in that office. So that's just kind of the idea or a background concept to mention before we talk about all the back and forth that's going to happen as it relates to the appointment of the CJP and the powers of the CJP. Back over to you, Tariq.
Thanks so much, Waris. Now, historically, the appointment of senior judges and the Chief Justice has been as Waris has mentioned, has been a point of contention between the executive and judiciary going way back. Now, also particularly during periods of military rule in Pakistan, when the executive has far more control over the selection process. However, since the 90s, the judiciary has been battling to assert its autonomy in this matter. The court has consistently asserted the principle of seniority in the appointment of the Chief Justice, as established in a number of landmark cases, including the Al Jihad Trust case and the Asad Ali case. Now, under the 18th Constitutional Amendment, Article 175A3 enshrined a process to ensure automatic selection based on seniority, mandating that the president appoint the most senior judge of the Supreme Court as the Chief Justice of Pakistan. Now, the 26th Amendment process introduces a new process where the Chief Justice is nominated by a special parliamentary committee. Now, this committee is a 12-member committee consisting of 8 members from the National Assembly, 4 from the Senate, and nominated by the parliamentary leaders based on proportional representation, based on party strength in parliament, basically. The committee is tasked for selecting one name from the 3 most senior judges of the Supreme Court. And that nominee is then forwarded to the Prime Minister, who sends it to the President for appointment. Now, this new system has also faced criticism for allowing greater political influence in the nomination process, enabling government through its influence on the committee to potentially bypass the most senior judge and nominate its preferred choice as Chief Justice. Now, experts have also warned that this could lead to increased judicial infighting and power struggles within the judiciary. Why is this such an important issue in terms of this ongoing struggle between the executive and judiciary?
Yeah, I think this is like as I mentioned before, I think it's a transformational change. It's a complete departure from how things have been done in the past, where really the judiciary, through its seniority and through its internal dynamics, controlled its own house. It was able to figure out who was supposed to be promoted, who was supposed to become Chief Justice, who would go from the High Courts to the Supreme Court. And now this is transferring most of that power over to political actors. And so many have seen this as a landmark sort of position that's been taken in the constitutional amendment process that brings in political sort of parties and political actors and all of the good and bad that come with that into a process that previously was very hermetic, almost like very sealed inside of the judiciary itself. And so that's why I think this is such a transformational period, and why there are so many distinct opinions about this parliamentary committee, and about this sort of injection of the political sort of actors into a process that was purely judicial before.
Now, the amendment also introduces significant reforms to the formation of benches within the Supreme Court itself, specifically through the addition of Article 191A, which establishes constitutional benches. Now, one of the main goals of reforms in recent years was to, as Wadis has already detailed, is to limit the power of the Chief Justice in constituting benches and to promote greater transparency in the decision-making. Now, prior to 2023, the Chief Justice had broad discretion in determining the composition of benches, assigning, allocating cases, and initiating public interest proceedings. As Wadis has mentioned, this authority has also been referred to as the master of the roster, a legal convention granting the privilege of deciding which judge and which benches hear specific cases. Now, this power is also mentioned also in the Supreme Court rules itself. Now, traditionally, the Supreme Court has constituted 2 to 3 judges in a divisional bench, which usually address routine matters like run-of-the-mill cases, while larger benches between 5 to 8 judges are formed for cases requiring constitutional interpretation. A full court bench would be assembled for matters of significant constitutional importance or national interest. However, as previously noted, the Chief Justice had discretion to establish these benches and could essentially control which cases were heard by which judges and benches. Now, in 2023, the government enacted the Supreme Court Practice and Procedure Act, which introduced a more consultative approach to bench formation. The law established a committee comprising of the court of the Chief Justice, and also included 2 most senior judges to oversee the constitution of these benches. Now, before this reform, any bench of the Supreme Court, regardless of side, could hear suo motu cases or appeals involving the interpretation of constitutional laws, with the Chief Justice maintaining control over which bench handled the case and determining its composition. Now, the 2023 law brought a significant change by mandating that in cases involving constitutional interpretation, the committee must constitute a bench of no fewer than 5 judges of the Supreme Court. This marked a shift towards a more structured and consultative process for addressing constitutionally significant matters. Now, under the new reforms introduced by the amendment, dedicated constitutional benches were established. These reforms retain the consultative process for forming these benches, but also aim to enhance efficiency of the court. By creating specialized benches for constitutionally significant cases, the reforms were intended to reduce the burden on regular benches and allow them to focus on more ordinary litigation more effectively. Another key aim was to ensure that the constitutional cases were handled by judges who actually had expertise in constitutional law, further improving the quality of judicial review in these cases. Now, Article 191A specifies that judges for the constitutional benches are to be nominated and determined by the Judicial Commission of Pakistan. The most senior judge among the nominated members will preside over the bench. Now, these constitutional benches have exclusive jurisdiction over cases involving the original jurisdiction of the Supreme Court. Now, these include the court's suo motu powers, its appellate jurisdiction, but this is limited to those appeals from the high courts that involve questions of constitutionality of a law and constitutional interpretation. And finally, the advisory jurisdiction. This is when the president desires to obtain an opinion from the Supreme Court on a question of law, and he considers this to be a matter of public importance. So overall, this means that suo motu cases, as well as appeals involving constitutionality and significant legal questions about constitutional interpretation, will now be restricted to these constitutional benches. Each bench must include at least 5 judges and must have equal number of judges from each province, ensuring representation from across Pakistan. This arrangement seeks to provide a more national and representative perspective in handling cases of national importance. The 2023 Act, along with a 2024 amendment, supports this new structure by establishing 2 key committees. One committee is known as the Bench Committee, which is responsible for constituting regular benches, while the second committee, known as the Constitutional Bench Committee, is there to determine whether a case falls within the jurisdiction of a constitutional bench. If it does not, the case may be transferred to the regular benches for adjudication. Now, all the current filed or pending petitions, appeals, and reviews under the constitutional bench's jurisdiction must now be transferred to this bench. Similarly, reforms have also been introduced to include constitutional benches in the high courts as well. Now, despite these reforms, concerns have been raised about increased political influence in the reconstitution of the Judicial Commission, which now establishes these benches and oversees the appointment of judges on these benches. Now, critics have worried that this may allow for greater executive control over the composition of constitutional benches and potentially affect the impartiality and independence of judges in politically sensitive cases. Waris, do you want to have anything to add to this?
Yeah, I think in particular here, as we'll talk about in a little bit, is the sui motu powers and where we stand with those. I think the formation of the constitutional benches is also really important because then, of course, the question comes up, which we'll talk about in a little bit, is that when you have a legal challenge that says the formation of the constitutional benches is in fact impermissible under the Constitution, should the constitutional bench rule on its constitutionality, or should a full bench be composed? Which is a question that was asked by Rabia in the chat as well. That's a big question that remains. What the validity of the constitutional bench is if the judiciary is considering under, like I said, the basic structure doctrine or the salient features doctrine, that in fact the creation of these constitutional benches in and of itself is impermissibly a violation of the independence of the judiciary. Who hears that? A full bench or a constitutional bench?
Now, as we've already mentioned, the amendment also introduced significant restrictions on the Supreme Court's suo motu powers, particularly concerning Article 184.3 of the Constitution. Now, this article empowers the court to exercise original jurisdiction in cases involving questions of public importance related to the enforcement of fundamental rights. Now, under this provision, the Supreme Court, as Waris has mentioned, can previously take notice of a matter or initiate action on its own notice without requiring a formal application. Now, however, the court has faced criticism over time for what many see as judicial activism and excessive involvement in political matters, often viewed as overreach of its powers. Now, to address these concerns, the government also in the Supreme Court Practice and Procedure Act aimed to regulate the exercise of these powers. The enactment of the law was triggered basically by a clash between the executive and judiciary over provincial election dates. Now, after former Prime Minister Imran Khan was removed from office through a parliamentary vote of confidence, he and his party were demanding immediate national elections, which were scheduled to happen later in that year. In order to force the election, his party, which was in government in the provinces of Punjab and Khyber Pakhtunkhwa, dissolved their legislative assemblies. The Constitution required that elections are to be held 90 days from the date of dissolution of a legislative assembly. Now, the Election Commission of Pakistan did not schedule those elections. Instead, the president of Pakistan, who was also a member of the PTI party, declared the date of those elections. So in February 2023, the Supreme Court took suo motu notice of this declaration. And in March, the Supreme Court ruled in favor of holding elections in Punjab and Khyber Pakhtunkhwa within 90 days, opposing the government's and the Election Commission's stance. This appears to be one of the many reasons the government felt pushed to address these powers. The 2023 law required that such matters first be placed before a Supreme Court committee to determine whether they involve questions of public importance related to fundamental rights. If the committee found that the matter was of such importance, it would then constitute a bench no fewer than 3 judges to adjudicate the case. This provision was later repealed by the 2024 amendment, as the matter has now become regulated under the 26th Constitutional Amendment. As mentioned earlier, suo motu actions now fall under the jurisdiction of constitutional benches. However, some confusion remains due to a key provision introduced by the amendment. The Supreme Court shall not make an order or give direction or make a declaration on its own or in the nature of suo motu exercise of jurisdiction beyond the contents of any application filed under this clause. Now, some legal experts feel that this effectively limits the court's discretionary power to initiate these actions, making such actions subject to an application. Supreme Court Justice Muhammad Ali Mazhar commenting on the amendment, clarified that the Supreme Court has not been stripped of its suo motu powers. The main change is that these cases will now be handled by constitutional benches. Why does there seems to be some confusion on whether or not the suo motu powers have actually been stripped or not? What is your take on this?
Yeah, certainly. I think as you know, as a lawyer, we're paid to look at certain words and certain terms, right? And the word here that I would emphasize that probably will be up for a lot of debate before the Supreme Court and will be a hot button discussion item will be any application filed, meaning the last clause is that what is an application? Could a letter from a person be sufficiently analyzed as an application? Because oftentimes what we've had in the past is that the court would take sui motu notice after someone had written a simple letter, right, to the court saying, hey, this is an injustice that I'm facing, X, Y, and Z thing has happened to me, I need your help. Now, if we look at this term, if we look at any application as being a formal application as it exists through, appellate jurisdiction or the original jurisdiction of the court, filed more likely by a lawyer, and if that's how it's interpreted, then I think what we knew as sui motu has gone away. But if we look at any application filed as being a very expansive clause, as being something that could include a simple letter from a person, a citizen who's facing some kind of persecution or prosecution, or some kind of a injustice, then we could see that sui motu still actually exists. It's just been curtailed in some ways. So I think that's where the application or the analysis really will focus on what does any application filed mean? Does it mean an expansive term or is it a very narrowly interpreted term? If it's narrowly interpreted, I believe we're out of the realm of what we traditionally understand as sui motu, but if it's more expansively interpreted, then it could remain that the Supreme Court still has most of its sui motu powers, just exercised in a different way, as Justice Ali Mazhar said.
Some other changes include establishing a 3-year term limit for the Chief Justice. Now, unless the Chief Justice resigns earlier or reaches the age of 65 or is removed from office. Now, prior to the amendment, as Watson mentioned, the Chief Justice did not have a specified term limit, but was required to retire at the age of 65. The amendment also adds inefficiency as a ground for the removal of a judge from a high court. It grants the Judicial Commission of Pakistan the authority to annually evaluate the performance of a high court judge. If the commission finds that the judge is inefficient, it may grant them a period to improve. If after that period the judge is still found to be inefficient, a report is sent to the Supreme Judicial Council. Now, the council investigates and decides whether the judge is incapable of performing their duties or is guilty of misconduct. Now, if the commission recommends removal, the president may then order the judge's removal from the office. Sorry, if the council recommends removal, then the president may order the judge's removal from office. Now, the bill doesn't really define what inefficiency is. Is this concerning?
That's exactly the issue here. I think on one hand, if it was a sort of examined in very like as a good faith attempt by the political branches, the backlog of judicial cases in Pakistan is very vast. In fact, in many instances, you could face 5 to 10 years of a delay in getting justice in some of your cases. So backlog is certainly an issue. Efficiency of the judiciary is certainly an issue. That is a good faith issue that exists. However, if inefficiency is used in a bad faith to remove judges who are not favorable or not giving favorable decisions to the political party in power, it could be a way for the political actors to control the future decisions of the high courts and of other courts by being able to remove certain judges who give critical opinions against administrative or other actions taken by parliament or by the prime minister, and could punish those judges by saying that they're inefficient and then not having a very narrowly tailored definition that could allow for both good faith and bad faith use of this clause. This has never existed before in the past as well. There's very limited instances wherein a justice or a high court judge could be removed or disqualified under the previous constitutional sort of order. But now this creates a new bucket, which could be either used in good faith or could be used in bad faith by political actors who want to limit the independence of the judiciary.
Juarez, can you go over a little bit about some of the implications of the judicial reforms?
Yeah, I think that there's certainly, and there's certain questions that we'll certainly get to, I think, at the end of that we have in the chat. But there has been sort of a statement, not just inside of Pakistan, about the concern that judges and members of the judiciary have raised about this. There is definitely, to go to George's question, there's definitely a debate happening within the judicial community. There's some judges and former judges who think that there should be some rules that apply to the Supreme Court and the Chief Justice, and that this amendment does do that in some ways, and others who are saying this is a complete violation of the independence of the judiciary in Pakistan. If we take a sort of zoom out from Pakistan to the international judicial community, the International Commission of Justice, which is an NGO of some of the most well-renowned lawyers and judges from around the world, they said the changes made by the 26th Constitutional Amendment seriously undermine the independence of the judiciary by unduly subjecting it to the executive and parliamentary control. The ICJ, the International Commission of Justice, understands that some reforms to the existing judicial system may have been needed to make the courts more efficient and accountable, as I mentioned before, and the judicial appointment process more transparent and inclusive, as Tariq had discussed. But these amendments are an attempt to subjugate the judiciary and bring it under the control of the executive, betraying the fundamental principles of the rule of law, the separation of powers, and the independence of the judiciary. And I think that's a very sort of well stated sort of claim of opposition against this 26th Amendment that was put forward by the International Commission of Justice. Again, not, it has members from Pakistan, India, and across South Asia, but it is an international sort of judicial organization. The Special Parliamentary Committee subsequently did nominate Justice Afridi, who was the third most senior judge, as the Chief Justice of Pakistan, going over two judges, Justice Mansoor Ali Shah, and some sort of wondered, is this punishment for those two senior judges who were passed over for a promotion to Chief Justice because they held against the government that's currently in power in the reserve seats case, for example? So this is an example where the violation of the historical rule of the most senior judge becoming the Chief Justice now being supplanted by this parliamentary committee, that it has led to a violation of that norm, where a less senior judge has been brought forward over more senior judges, perhaps or potentially because the more senior judges have been critical or have been aggressive in their sort of review of what the administration or what the political parties are doing. So this goes right into the question of the independence of the judiciary and whether the independence of the judiciary remains if politicians are able to control this process. There are also concerns about court packing. As I mentioned, there are attempts that are being made to increase the size of the Supreme Court. It's already been increased by some seats. There's also more talks of that happening, which would mean that through this new politically controlled process, there could be a packing of the court with judges who are or have some kind of allegiance or have some kind of relationship with political parties, who are then brought onto the Supreme Court to defend the political parties once they make decisions as parliament or as the prime minister. So of course, there's a question of whether preferred judges with political affiliations are being brought forward and promoted or brought onto the court because of those political affiliations and not because of their ability as judges. And then there is judicial infighting happening here. Four Supreme Court judges urged the CJP to hold off on appointments to the Supreme Court until the challenges to the 26th Amendment were heard. There was a question about high court judges and the transfer of their sort of like, in terms of seniority, being able to be promoted or being able to be shifted. That's also being questioned. And then the jurisdiction of the regular benches versus the constitutional benches, which is generally a large issue that has to play out in Pakistan. Generally speaking, but also will come up when we look at the petitions that are arguing both in favor or against the 26th Amendment. So the question about whether the regular benches control or the constitutional benches control is important. And the last thing is that the law isn't so clearly cut. Some issues that might have regulatory sort of parts to it also have constitutional questions attached to it. So then the question becomes, if a case presents both of those questions, does it go to a regular bench or does it go to a constitutional bench? Is the constitutional bench able to hear regulatory matters, or should that go to a regular bench, and the regular bench can then hear the constitutional matters? Because oftentimes there's an overlap between the two issues. So that's something that I would mention that's going to be hotly debated in the next coming months and coming years under the evaluation of the 26th Amendment, which I think Tariq will now talk about.
Now, the legal challenges to the amendment unfolded both before and after its enactment, with petitions questioning the amendment's constitutionality. Now, on October 14th, the Sindh High Court rejected a petition seeking to prevent the federal cabinet from approving the amendment proposal. The court held that it could not rule on the amendment's constitutionality before it became an act of law, and should only intervene once Parliament enacts the law as an act. The petitioners also requested that the court mandate a public debate on the amendments for at least 60 days, but this was refused as well since the court found no such constitutional requirement. Shortly after, on October 17th, the Pakistan Supreme Court dismissed a plea against the amendment following a request for its withdrawal. A group of lawyers led by the former Supreme Court Bar Association president had filed a petition to restrain the government from tabling the bill before Parliament. However, the petitioners decided to withdraw their application, and the bench disposed of the case. Now, after the bill's enactment, various petitions were filed in different high courts. The Lahore High Court dismissed one such petition, while the Sindh High Court continued to hear additional challenges. Now, several petitions are also before the Supreme Court, filed by entities like the PTI, the Lahore High Court Bar, and a group of women lawyers as well, among other entities. The arguments included in these petitions include that the new bill violates the principles of judicial independence and the separation of powers. And as Waris had mentioned, they also use the argument that it alters the fundamental structure of the Constitution. Another key argument that is used is that the amendment, how it was passed, was procedurally defective because members of Parliament allegedly voted in favor of the amendment passed under duress, coercion, or unlawful inducement, raising questions regarding the legitimacy of its passage. So these legal challenges reflect some of the ongoing concerns about the independence of the judiciary, the separation of powers, and of course, the integrity of the constitutional legislative process in Pakistan. Now, one of the requests from the petitioners has been that the court form a full court bench to hear challenges of this petition. Waris, can you clarify the importance of this? I think you touched upon it, but I don't know if you want to expand a little bit more on this.
Yeah,
Yeah.
certainly. I think the question becomes sort of like if we're questioning whether the constitutional bench should ever be created, should that what some would call illegitimately created constitutional bench be able to hear claims about its own validity, or should it be a full court? Because essentially, when it comes to the amendment review process, it's been an all court sort of discussion because it's of such high importance. As Tariq had mentioned earlier on, that the matters of highest importance are oftentimes heard by the full court. So the question then becomes, it's kind of a meta question, but it is a question that is being asked. And different sort of legal actors have different opinions on this, whether a constitutional bench should be the one that reviews its own legitimacy under the 26th Amendment. Tariq, if you like, I can address a few of the questions perhaps in the chat that
Yeah,
are particularly important.
go on
Yeah,
ahead. I think you've already addressed some of them, so already.
yeah,
So
certainly.
yeah.
I think for Jenny's question, what role do bar associations and councils have in supporting and opposing? I think the bar councils are the ones who are litigating this issue. So I think like the main role that's being played here, not only in the public narrative and what's being discussed publicly with the bar, which the bar associations, of course, do engage with the public on these issues. The main thing is that a lot of bar associations are bringing, as bar associations, claims before the Supreme Court to call for this 26 amendments overruling, or mostly it's calling for the overruling. It's not really talking about upholding it. The second question that I thought was really important from Ruth is that why would reformers want to increase political influence over the Judicial Commission and the selection of the Chief Justice? What is the party in power, and why are they willing to limit the authorities of the judiciary? I think because the two current ruling parties, the People's Party, Pakistan People's Party (PPP), as well as the Noon League (PMLN), both have been burned in the past by the Supreme Court. Both have faced very serious challenges to their power and to their actions by the Supreme Court, oftentimes under these sui motu powers, oftentimes under judges who haven't been reviewed by political appointees or politicians for their qualifications to be on the court. So I think they're trying to push back on the power grab that came their way essentially from the judiciary, and trying to push back on that to try and supplant or take back some of the powers by being able to control the Supreme Court's appointment and review process.
One thing I wanted to add, and this relates to the question that George had about factions within the judiciary and the fighting, and then you kind of touched on this on the battle between jurisdiction between the regular courts, regular Supreme Court's benches, and the constitutional benches. There was an interesting thing that there was a recent case in the last year where a constitutional challenge was made to sections of Pakistan's customs law. And Justice Mansoor Ali Shah was in that case, and the committee gave that case to a regular bench, but then the committee withdrew that case and then gave it to a constitutional bench. And then in a different case, this is a little bit funny. Justice Mansoor Ali Shah amusingly joked that leave some cases for us too, and then he goes that. And then he goes that do not take all cases to the constitutional benches. Let us have some too. So there's definitely some tensions on how this is playing out.
Certainly. And then I think Hannibal asked a great question about what are some of the other political and judicial factors that have driven these reforms. I mean, Pakistan is a country that you can't ignore the role of the military, and the military has also been on a collision course on several occasions with the Pakistani Supreme Court. And so I think there is that factor here that bringing them in control and diminishing their power a little bit will allow the military to also do the actions that it feels necessary to do. Alternatively, I think there's the political factions have kind of broken out in favor and against the 26th Amendment based on whether they're in the opposition or they're in the ruling sort of coalition in the government. The ruling coalition, the People's Party, the Noon League, the sort of very loose coalition that's been formed to run the country is defending the 26th Amendment, whereas I think a lot of the opposition parties, including PTI, are really fighting tooth and nail against the amendment because they fear that the current existing sort of people in power will be able to pack the courts with people that are unfriendly to PTI and to other opposition parties, in which case they will face a lot more judicial power and a lot more judicial punishment potentially for actions that they do. So there is that fear that's existing in the political opposition as well currently.
I think we've run out of time. That brings our webinar to a close. I would like to thank again Dr. Hussain again for sharing his tremendous expertise and some of the great insights. And I'd also like to thank the online audience for taking the time to hear our presentation. If you have any further questions and you would like any other more detailed answers about some of the issues that we've brought up today, feel free to use Ask a Librarian feature on our website. Hope to see you soon for future webinars as well. The next one will be on March 27th, 2025, titled Climate-Induced Migration Responses in the Pacific by one of my colleagues, Kelly Buchanan. Thank you so much for everyone. Take care. Bye-bye.